হ্যালো। হ্যাঁ হ্যাঁ, শোনা যাচ্ছে ক্লিয়ার।
Hello, Shantanuda. Hello, Shantanuda. Am I
Hello.
audible?
Hello. Yeah, you are
Hello.
audible. Loud and clear.
Thank you. Okay,
Loud and
okay.
clear.
Thank you. Thank
Welcome,
you.
welcome.
শান্তনু 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 বলছি নবনীতা ম্যাডাম জয়েন করতে চাচ্ছেন। হ্যাঁ, ওনার ফোন নাম্বারটা তোমাকে বলবো, তুমি ওনাকে ফোনে সেন্ড করতে পারবে লিঙ্কটা? আমি বলছি, হ্যাঁ নাম্বারটা বলছি, জাস্ট আ মিনিট। 86-177-80927। ইয়েস বর্ণালী প্লিজ। হ্যাঁ, হুম। বলছি হ্যালো। হ্যাঁ বর্ণালী, পাঠিয়েছো? ওকে, পাঠিয়ে দাও। হুম, ঠিক আছে। ওকে, থ্যাংক ইউ সো মাচ। আমি বলে দিচ্ছি। পেয়েছেন? পেয়েছেন? হ্যাঁ হ্যাঁ, দেখুন। এই 1 মিনিট। বর্ণালী, তুমি হোয়াটসঅ্যাপ করেছো ম্যাডামকে? ওই নাম্বারে হোয়াটসঅ্যাপে পাঠিয়েছো? হ্যাঁ, আপনার ওই নবনীতাজির আগের নাম্বারটা যেটা কল করেছিলেন ওইটাতে হোয়াটসঅ্যাপ করেছে বর্ণালী। হুম, হুম, হুম। শান্তনু, আর ইউ হিয়ার? শান্তনু
বলুন।
বলছি নবনীতা জয়েন করছেন। হ্যাঁ,
আচ্ছা,
ওকে। বর্ণালী হ্যাজ সেন্ড, এক্ষুনি কল করেছিলেন। বর্ণালী ওনাকে পাঠাচ্ছেন, এটা হোয়াটসঅ্যাপ করেছেন।
Good evening, Navanita Di. Navanita Di?
Yes, now she's joined.
Yes, she has joined. I can find her name here. Good
Yes,
evening,
yes,
Navanita Di. On behalf of Netaji Nagar Day College, I extend a warm welcome to Professor Navanita Chatterjee, who is a professor of philosophy at Dinabandhu Andrews College, Goria, and is a nominee of the University of Calcutta on the governing body of Netaji Nagar Day College. I extend a cordial and warm welcome to her.
He has not yet heard Shantanu, I think.
I think it is 5:30, so
we
shall
would
I?
Start. Yes, I think we should start. Okay. Ma'am has been waiting.
Yes. So good evening, everybody. It gives me great pleasure to welcome you all once again to yet another webinar being organized by Netaji Nagar Day College this Sunday, the 30th of August, 2020. I am Dr. S. Ganguly of the Department of English, and I am one of the conveners of this webinar being conducted today. As you all are aware, ever since the lockdown started, the different departments of our college have, either singly or in collaboration, organized a number of seminars for the academic development of one and all. This seminar is a result of a notification issued by the University Grants Commission, the UGC, on 25th June this year, a few months back, directing all higher educational institutions to organize webinars on gender sensitivity and women's issues, especially the problems faced by women in the COVID-19 scenario. In this context, the Internal Complaints Committee of Netaji Nagar Day College wanted a program in which the physical, mental, emotional, social, and psychological problems of women could be discussed and analyzed in the purview of the unnatural circumstances that we are going through presently, as well as find out what legal remedies are available to women in these circumstances. We are very fortunate that to tell us more about this subject, we have Dr. Shochi Chakraborty, who is a professor of law, as well as the Dean of the Faculty of Law, University of Calcutta. To illuminate us more about this issue, I now invite the principal of Netaji Nagar Day College, Dr. Shonali Banerjee Josh, to say a few words on the occasion.
Thank you, Shantanu. I am indeed honored to extend a hearty welcome to our resource person for today's webinar organized by the Internal Complaints Committee of Netaji Nagar Day College. We have with us today Professor Dr. Shochi Chakraborty, Professor of Law as well as Dean Faculty of Law, University of Calcutta. We are honored, ma'am, that you have agreed to deliver your lecture for us today. We have with us today our governing body member, Professor Navanita Chatterjee. She has always been very supportive, very encouraging, and she has been particularly very, she has always encouraged us about the activities of the ICC. So, Madam Navonita Di, we welcome you on behalf of the college. I also extend a hearty welcome to all my colleagues, students, and as well as participants from India as well as from other countries, neighboring countries. Actually, we find that even in this 21st century, in spite of much talk about women's empowerment, women's liberation, domestic violence against women is still going on. It is a menace, it is an evil, the social evil, which we have not been able to eradicate, particularly in our part of the globe. It is really a burning issue, though though a large section of women today are now economically independent, still we find that domestic violence against women is still continuing. And we must confess that we know very little. In fact, we do not know what are the remedies, what are the laws that can protect women against domestic violence. So, against this background, the Internal Complaints Committee of our college thought it pertinent to organize a webinar on this topic, legal remedies for women against domestic violence, particularly during this ongoing pandemic situation. I'm sure that we will be able to learn a lot from Madam's discourse today. So, with these words, I once again welcome you all to today's webinar. Thank you.
Thank you very much, Dr. Sonali Banerjee Josh, our Honorable Principal, for her very enthusiastic speech and for putting the subject of today's webinar in its proper perspective and highlighting what the expectations of all of us are regarding the issue of legal remedies that women may use to protect themselves in abnormal circumstances that we are passing through. With this, we come to the end of the inaugural session. We will now move to the technical session, in which we will have the pleasure of listening to Dr. Shochi Chakraborty, Professor of Law and Dean of the Faculty of Law, University of Calcutta. I now invite Dr. Shochi Chakraborty to deliver her lecture. But before that, I request Dr. Bornali Dotto to formally introduce the resource person for today's webinar. Dr. Bornali Dotto teaches in the Department of Mathematics in Netaji Nagar Day College and is the convener of the Internal Complaints Committee of this college, as well as the convener of today's seminar along with me, Dr. Bornali Dotto. many thanks, Dr. Bornali Dotto, for formally introducing our resource person for today. I now hand over the platform to our resource person so that she may deliver her much awaited lecture. And before that, I once again record my gratitude to Professor Dr. Shochi Chakraborty for taking time out of a busy schedule to agree to deliver the invited lecture in today's seminar on a topic of great relevance in the circumstances that we are passing through. Now I request Dr. Chakraborty to deliver her lecture.
Thank you, Dr. Shantanu Ganguly. Well, all ladies and gentlemen present here, good evening to all of you. Internal Complaints Committee of Netaji Nagar Day College, Kolkata, has organized this state-level webinar on a very relevant topic and sensitive topic of domestic violence in present pandemic situation, which has created great havoc all over the world. Already more than 2 crores 50 lakhs people have been affected till now, and around 8 lakhs people died in the world. In India, more than 35 lakhs people are affected by this coronavirus, and more than 63,000 are dead. During this critical situation, Netaji Nagar Day College has organized this webinar and entrusted upon me to lead a discussion on the domestic violence situations in India and the legal remedies which are available to women victims of domestic violence and for giving them proper justice. I feel myself honored and privileged for getting this opportunity to speak on such a burning and sensitive issue today. I am highly thankful to Principal of this college, Madam Dr. Sonali Banerjee, and also to the organizing committee for giving me this privilege. I am also thankful to governing body member Nobinita Deep, who is present here. And my special thanks to Dr. Shantanu Ganguly and Dr. Barnali Datta and other organizers who have taken all the initiatives for organizing this webinar. My sincere regards and thanks to all participants of this program. I congratulate you all. Now, the issue of domestic violence is a very, very sensitive issue. Actually, this is very different from other kinds of violence. Now, we can know about too many violence, different kinds of violence against women. Today's topic is legal remedies for women against domestic violence in contemporary situation, COVID situation. Now, first of all, I will start from the quotation of Sydney Brandon, that in her book, Violence in Family of 1976, she mentioned that statistically it is safer to be on streets after dark with a stranger than at home in the bosom of one's family, for it is there that accident, murder and violence are likely to occur. A central theme for the women's movement all over the world has been violence against women, both in their homes and outside. This is directly linked to their unequal position in the patriarchal society. cutting across both class and community. Crime and violence against women is a global phenomenon, and it is the result of gender inequalities and discriminations against women. We have got so many empirical evidences of gender inequalities and discriminations from all over the world, different countries of the world, which denote the masculine control over feminine gender, like Chinese foot binding, female circumcision in Africa, Middle East, Jordan, Syria, and other countries, European witch murders, wife sale in England, witch hunting, and sati, dowry killing, and domestic violence in India. In almost all societies of the world, women have been subordinated to men. Women played a passive part in society. They were only a thing of enjoyment for men. In theory, women were respectable, but in practice, they are the subjects of cruelty, ill treatment, and all sorts of misbehavior by males. And in ancient period, actually, what Manu stated, that yatra naryastu pujyante na ramante tatra devata. That means where women are worshipped, the God is present there. But in fact, this principle was in theory, not in practice. Because we have seen the instances that Lord Rama rebuked Sita after war with Ravana. In Mahabharata, Draupadi was divided by the 5 Pandavas periodically for their sexual enjoyment. Ours is the patriarchal society and male dominated. Patriarchy is directly related to the crime against women. Crimes are patriarchal manifestations, both at public and private sphere of life. Now the question is, what is patriarchy? It means a form of social organization in which the father is the supreme authority in the family, clan, or tribe, and descent is reckoned in the male line, with children belonging to the father's clan or tribe, a society, a community, or the country based on this social organization. That is patriarchy. Now, patriarchal manifestation operate both in public and private domain spheres of life. In public sphere, we find sexual harassment at workplace, inequality in employment, underrepresentation in vast majority of the legislatures around the world, underrepresentation in the higher echelons of professions, management and industry, rape at workplace. In private sphere, division of labor within the family, invisibility of women's work. Women are confined to the private domestic world, and which is traditionally unregulated by law. Simone de Beauvoir, a famous sociologist, in her book The Second Sex, she wrote, "This humanity is male, and man defines woman not in herself but as relative to him. She is not regarded as an autonomous being, she is defined and differentiated with reference to men and not he with reference to her. She is the incidental, the inessential, as opposed to the essential. He is the subject, he is the absolute, but she is the other. This was written by Simon D. Beauvoir in her book. Now, friends, patriarchy has rendered women to abuse, manipulations, and violence. Domestic violence is inherently and inseparably connected to male power and female powerlessness, male dominance and female subordination. Domestic violence perpetuated in the private sphere of life, the home, is a prime manifestation of patriarchal authority. The gender inequality of the public world becomes reinforced in the private world of the family. Before going into details of domestic violence, we have to understand what is violence against women. What is the meaning of violence? How it is explained in different human rights instruments and other laws. Violence means violation of rights and fundamental freedoms of women and impairs or nullifies their enjoyment of those rights and freedom. In 1993, United Nations General Assembly entered a resolution and there was a declaration on elimination of against men. So Article 1, if we go through Article 1 of the Declaration on Elimination of Violence Against Women, and also the platform for action from the 4th World Conference in Beijing on Women in the year 1975, both define violence as an act of gender-based violence that results in or is likely to result in physical, sexual, psychological harm or suffering to women, including threats of such acts, coercion, or arbitrary deprivation of liberty, whether occurring in public or in private life. Therefore, violence is an act of aggression that crosses the boundary of another person's autonomy and identity. It is a coercive instrument to assert one's will over the another, to prove or feel a sense of power. Domestic violence is a human rights issue, and this is serious deterrent to development. The phenomenon of domestic violence is widely prevalent, but has remained largely invisible in the public domain. Domestic violence manifests as verbal, physical, psychological, financial, economic abuses, often in forms that are more subtle than the violence elsewhere in society. Familiarity with the perpetrator and filial values deter resistance. Closed doors alienate the victim from remedies. If the victim reconciliate with subjugation, it is violation of human rights, liberty and human dignity. Victims' inability to access law makes legal remedies ineffective. Although we have got many legal remedies, but they become ineffective because the victim can't access, due to many reasons, can't access to the law which has been made by parliament. They cannot access, there is no proper access for the victims. So many of the victims of domestic violence are at a risk of further violence or even death when they attempt to leave abusive relationships. Therefore, most incidents of domestic violence go unreported because women are themselves reluctant to bring a complaint against a member of their own family. They are very much hesitant. They will not go for complaining because they think that problem will be solved in near future. All these factors render the issue of domestic violence very different from other forms of violence because of the women's weak and vulnerable position in their home. Now, what about the statistical data? Statistical data on the incidence of domestic violence in India is very scant, and the few studies which are available indicate that physical abuse of Indian women in their home is rampant. They are rampantly tortured in the home. There are harassments, humiliations, and so on. Domestic violence against women figures as the top category of violence against women in 2018. According to data from the National Crime Record Bureau, that is Crime in India report, compiled by NCRB, the crime rate per lakh women with per lakh women population is 58.8 in 2018. If we compare with 2017, in 2017 it was 57.9. Now, out of total crimes registered under Indian Penal Code against women, the majority of the cases were registered under the cruelty by husbands or his relatives. In India, during the first 4 phases of COVID-19 related lockdown situation, Indian women filed more domestic violence complaints than recorded in a similar period in the last 10 years. In fact, 86% women who experience domestic violence do not seek help in India. In 2020, between March 25 and May 31st, 1,477 complaints of domestic violence were made by women. This 68-day period recorded more complaints than those received between March and May in the previous 10 years. About 86% women who experienced violence never sought help, and 77% of victims did not even mention the incidents to anyone, to anybody. Only 14.3% of victims sought help from a source. Among these 14.3%, only 7% reached out to relevant authorities, the police, the doctors, lawyers, social activists or social organizations, social service organizations. So more domestic violence complaints in red zones during lockdown are found. Examining this data, the researchers have found that the average number of monthly domestic violence complaints per red zone district was below 1.5 in March 2020, which went up to almost 2 in May 2020, meaning thereby that 45 complaints in 30 days in March and 60 complaints in May 2020. Now, the National Commission for Women has seen a spike in the complaints it receives. Its chairperson, Rekha Sharma told the BBC. Now, NC, they have actually launched WhatsApp helpline for women during the lockdown. The messaging app is a safe option for those who cannot make calls for fear of being overheard by the other members. Between 23rd March and 16th April 2020, the first 3 weeks of lockdown, the Commission received 239 complaints of domestic violence. This was a significant jump from 123 complaints it received before the lockdown. So this was actually regarding the data, what I explained. Now, what might be the reasons for domestic violence during lockdown? What are the reasons behind? I can say here that one economist and professor, Ashwini Deshpande, at Delhi's Ashoka University, he has mentioned that the abuser, he lays down the reason for domestic violence. The abuser feels frustrated and angry because of lack of control due to the constraints imposed by lockdown, and this prompts him to exercise greater control by abusing his partner or children, often with violence. Early in April, UN's Secretary General Antonio Guterres said that there was a horrifying global surge in domestic violence amid lockdowns. The calls to helplines doubled in Lebanon, Malaysia, and tripled in China, compared with same time last year, according to UN. Now, according to BBC reports that on 18th April, one lady, Tara, whose name hasn't on request, went online to search for helplines. Her husband of 15 years in marriage has been abused emotionally and at times even physically, but job, which kept her busy and out of the house for most of the day, and her husband often traveled for work out of the town, which kept him out. This lockdown, however, changed everything. Tara lived in a constant fear that anytime husband may change his mood. Her mother-in-law and her husband both taunted her, abused her, that she is not a good wife or mother. They ordered her to serve elaborate meals and treated her like a domestic worker. Now, unable to bear this abuse and beatings, she decided to seek help. She found a Facebook page run by Invisible Scars, a support group, and contacted them. The founder of the support group laid out all the options which are available to Tara, that is legal remedies, that she can register a police complaint, she can seek legal separation, or even talk her husband into going for counseling, and so on. Tara warned her husband that she would go to the police. Abuse stopped for a few days but started again. She says that leaving is not an option. She cannot trouble her parents and her young child. Only God can save her. So this is the situation actually of the women in India generally, that God will help. They will not go for any proper complaint or go for any legal remedies. So this is the irony. Now, I am frankly speaking that in India, divorce is socially discouraged. Everybody knows it. That even in educated family, the divorce is socially discouraged, and women do not want to leave an abusive spouse. They want to teach them a lesson or make them behave better. A few families would support daughters who want to walk out of the abusive marriages. Even parents do not support, especially if they have children, as Tara does. And leaving to go to stay in a shelter home or with parents is especially hard during lockdown period when the transport has been very limited. So this is the irony actually, that even after suffering a lot, the women are not coming to complain. Most of the time they do not know what are the laws, the legislations. We have got many other laws under IPC. There is one section 498A IPC, which was put in IPC by the amendment of 1983 IPC Amendment Act. This section actually is very, very important, that it explains regarding the cruelty by husband and in-laws. That if the woman is harassed physically, mentally, or she is harassed for any dowry event, or any demand is there, or she is being coerced for that, then she can file a complaint to the police. And this actually offense under 498A IPC is cognizable and non-bailable. But very few complaints are made under this. And even sometimes, if they are made, sometimes this law is even abused also. So that is a criminal law remedy. Now, Domestic Violence Act was intended to be made a civil law. But due to certain powers have been given to the magistrate, and even the offences under this, the breach of law has been made offences here. Then, therefore, the law has become quasi-civil in nature. This is not purely civil, but quasi-civil. So, Protection of Domestic Violence Act, Protection of Women from Domestic Violence Act 2005. This act provides for more effective protection of the rights of women guaranteed under the Constitution who are victims of violence, and for matters occurring within the family, and for matters connected therewith, or incidental thereto. And this act was, I told you that this was intended to make it civil in nature, but this is now quasi-civil in nature. Act of violence is treated as an offense, and punishment is provided for violation of the orders. Now, what is the definition of domestic violence as per the Act? As per the Protection of Women from Domestic Violence Act, Section 3. Section 3 lays down that protection of women for the Domestic Violence Act includes that will constitute harms or injuries or endangers to health, safety, life, limb or well-being, whether mental or physical, of the aggrieved person, or tends to do so, and includes causing physical abuse, sexual abuse, verbal and emotional and economic abuse, or harasses, harms, injures, or endangers the aggrieved person with a view to coerce her or any other person related to her to meet any unlawful demand for any dowry or other property or valuable security, and also has the effect of threatening the aggrieved person or any person related to her by any conduct mentioned in above clauses, or otherwise injures or causes harm, whether physical or mental, to the aggrieved person. Now, what is the meaning of physical abuse? Physical abuse means bodily pain, harm, danger to life, limb, health, criminal force, using of criminal force, assault, and so on. Now, what is the meaning of sexual abuse? Sexual abuse, such sexual conduct which humiliates, degrades, or otherwise violates the dignity of women. Then, what is the meaning of verbal and emotional abuse? That is insult, humiliation, for example, not having a child or a male child, threat to cause physical pain. There are instances in the family that if the woman is not having a child or not bearing a male child, then she is very much accused and humiliated and tortured. Now, what is economic abuse? Deprivation of economic or financial resources. Stridhan, any property jointly owned or separately owned by the aggrieved person. Disposal of household assets, valuables, shares, securities, bonds, any movable or immovable property in which the aggrieved person has an interest or is entitled to use by virtue of domestic relationship, or which may be required by the aggrieved person or her children or her stridhan. Now the question is, who is an aggrieved person? Section 2A of the Domestic Violence Act explains about the aggrieved person. Aggrieved person means any woman who is or has been in a domestic relationship with the respondent and who alleges to have been subjected to any act of domestic violence by the respondent. Then there is another term which is used here, domestic relationship. Section 2F defines domestic relationship. It means a relationship between two persons who live or have at any point of time lived together in a shared household when they are related by consanguinity, marriage, or through a relationship in the nature of marriage, adoption, or are family members living together as a joint family. So this is very, very important here. Domestic relationship, it is to be understood by everybody. What kind of relationship? Consanguinity, that is even father can be challenged for violating the rights of the daughter, that is domestic violence, and the mother can also file a case against son. Then marriage or to nature of marriage. Nature of marriage means live-in relationship, which is presumed. The marriage which is by presumption, that long cohabitation is there and the parties are treated as husband and wife. Then relationship by adoption and other relations, family members which are living together as a joint family. Now, who is a respondent? Respondent means the opposite party against whom the complaint can be made. That is section 2Q. Respondent means any adult male person who is or has been in a domestic relationship with the aggrieved person and against whom the aggrieved person has sought any relief under the Act. Legally married wife or female living in relationship are also included under the Act. Women who are sisters, widows, mothers, single women are entitled to get relief under the Act. A mother is entitled to file complaint against son and also a daughter-in-law if she is maltreated by them. Now there is a term used, shared household, in the definition. Now section 2S defines what is a shared household. It means where the aggrieved person lives or at any stage lived in a domestic relationship, either singly or along with the respondent. Shared household may be owned or tenanted. It may be the person must be having the title, might be having the title, or it might have been taken on rent, tenanted, owned or tenanted by either the respondent or aggrieved person. It may be a household where both might have the right title interest or not. It is immediate. It may be the house of even joint family. Now here, friends, it is very important to note that in India there is no concept of matrimonial home and matrimonial property, and no law is there to tackle the problem of marital breakdown of the spouse. Wife who is victim of domestic violence cannot claim any right to live in the matrimonial home. That is why the Domestic Violence Act provides there is a provision for right to residence in the shared household. Now, this right to residence actually is not enough. There must be some substantive right to the property. Right to the property, that means the matrimonial home. That as soon as the girl is married, she goes to her in-laws' house. But she lives there, say for 10 years, 15 years, and she sacrifices her life. She works there day and night. But if she wants to separate herself from the husband due to certain cruelty, domestic violence, she will have only the maintenance right. She doesn't have any property right where she can say that I live here or I right to live here. She cannot say. If we compare it with other countries like England, laws on matrimonial property. The Family Law Act is there of the year 1986. Matrimonial Homes Act in England 1967, which were passed to provide for matrimonial property concept. In other countries also, I've seen that in Canada, in other countries, we can say they have got their matrimonial laws, matrimonial property laws, family law act like that. But in India, we don't have. Although the bill was prepared, but still, and this is not passed. Now, I come to the complaint portion. Now, who can complain under this act? Who are the persons who can complain? Anybody can inform the protection officer regarding an act of domestic violence. There are protection officers appointed by the government, state government in the districts. So who can complain? The neighbors, the social workers, relatives, they can inform on behalf of the victims. And even the victim can also complain. Now, who are the protection officers and what are their duties? There are certain sections in Protection of Domestic Violence Act, Section 8, where it is mentioned that the state government shall by notification appoint protection officers for each district. The protection officers shall be preferably the women. They shall be under the control of the magistrate. Now, what are their duties? Section 9 of the Act mentions about the duties that provides for the duty of protection officers. To assist the magistrate to discharge his functions under this Act. To report a domestic incident after receiving complaint of domestic violence. To forward the application to the judicial magistrate and forward the copies of domestic incident report, DIR, that is called DIR, to the police officer in charge of the local police station. Now, the protection officer has to make an application in prescribed form to the magistrate if the aggrieved person desires to claim a protection order. Now, the duty of the protection officer is also to ensure that the aggrieved person is provided legal aid free of cost. That is under Legal Service Authority Act 1987. Actually, this is the Central Act, and under Central Act, the legal aid authorities are working in all the states of India. So they have the legal service cells, and they are helping the victims. Now, the duty of the protection officer is also to maintain a list of all service providers and to make available the safe shelter home if it is required or requested by the victim or her relatives, and also to get the aggrieved person medically examined. So protection officer has got a number of duties. Now, to ensure that the order for monetary relief under section 20 is complied with. Now, the service providers. There is a provision for service providers under the Act. Now, section 10 provides that any NGO, voluntary association, registered under the Societies Registration Act 1860 or any company whose main objective is to protecting the rights and interests of women by providing legal aid, medical or financial assistance shall register with the state government as a service provider. So they are service providers. So any NGO, any voluntary organization, but they must have been registered already under Societies Registration Act. And then they will register themselves to the state government as service provider. Now, what are their duties and powers? A service provider shall have the power to record the domestic incident report DIR in the prescribed form. The copy will be forwarded to magistrate and protection officer, and his duty is to get the aggrieved person medically examined and forward a copy to the protection officer and to the local police station. It is also his duty to ensure that the aggrieved person is provided a shelter in a shelter home. Now, I come to the powers of the magistrates, who are very important in this act, performing the important task, because all the main powers are vested in them through sections 12 to 23 of Protection of Domestic Violence Act. Sections 12 to 23. Now, how the orders and reliefs can be obtained by the magistrate? That first of all, an application to magistrate will be made by the aggrieved person or by aggrieved person herself or a protection officer or any other person on behalf of aggrieved person can be made. Now, what are the different kinds of reliefs and orders? There are different types of orders, like compensation order, compensation or damages, then protection orders, residential orders, monetary relief, custody orders, interim and ex parte orders. These are the different kinds of relief which a magistrate can give. Now, magistrates shall, after receiving the application, what happens? Magistrate shall fix the date of hearing within 3 days from the date of receipt of application. Within 3 days. And magistrate shall try to dispose every application made within a period of 60 days from the date of its first hearing. A notice of date of hearing is to be served upon the respondents through protection officers, because if the notice is not served, that means there is violation of natural justice, and the notice will be served through protection officer upon the respondents of the opposite party. Now, there is a provision for counseling. This is very, very important. Counseling is to be done. As per section 14, magistrate can at any stage of the proceedings under this act direct the respondent or the aggrieved person to undergo counseling with any member of a service provider. Because counseling is very important, as to break a home is very easy, but to make a home is very difficult. That's why everywhere, not only in domestic violence, under the Domestic Violence Act, but in every law, at every time, even at high court level, superior level, the counseling is done by the judges, and even the lawyers try to do the counseling. So counseling is very, very important. But now magistrate can pass the following some orders under section 18 to section 23, starting from 18 to 23 under the Domestic Violence Act. Protection order, section 18 of the Domestic Violence Act provides that magistrate can pass protection orders in favor of aggrieved person and prohibit the respondents from doing certain things. So, how can he prohibit? He can prohibit the respondent from committing, aiding, or abetting the act of domestic violence. Then, from contacting and communicating the aggrieved person physically or electronically. The magistrate can prohibit the respondent that he should not communicate either physically or electronically even. And magistrate can also prohibit respondent from alienating assets, the financial property, that is bank lockers, including Stridhan, etc. Then magistrate can also prohibit the respondent from causing violence to the members of family who give assistance to a aggrieved person. Those who are assisting the victim, the respondent cannot do any harm to them. Now, as per section 19 of the DV Act, Domestic Violence Act, magistrate can pass residential orders. The residential orders to protect the aggrieved person in the shared household. He can restrain the respondent from alienating or disposing of the shared household. He can also direct the respondent to make any alternate provision or accommodation for aggrieved person. Magistrate can also direct the respondent to deliver the possession of her Stridhan or any other property or valuable security to which she is entitled. Actually, what is Stridhan? Stridhan includes the assets or the properties or the ornaments which are given at the time of the marriage by anybody, by either, it may be by in-laws, it may be by parents or so on, or any other relative, the ornaments or any security, valuable security. And if the respondent is not delivering her the Stridhan, then he shall also be liable under section 405 and 406 of IPC, not only against under the Domestic Violence Act, under section 405 and 406 of IPC for criminal breach of trust and criminal misappropriation of property. Now, section 20 of the DV Act provides monetary reliefs. What kind of monetary reliefs? That magistrate may direct the respondent to pay the monetary relief to meet the expenses incurred and losses suffered by the aggrieved person and any child of aggrieved person as a result of domestic violence. Then there are custody orders. Custody orders can be passed for welfare of the child and children to the aggrieved person. Then as per section 22, compensation orders can be passed. Magistrate can direct the respondent to pay compensation and damages for injuries, including mental torture and emotional distress caused by acts of domestic violence. Now there are other reliefs or the power of the magistrate to grant interim or ex parte orders against the respondent. If magistrate is satisfied that the situation so demands and there is a prima facie domestic violence has taken place, then he can order for he can pass an interim order and even the ex parte order. Now there are other provisions which are also very important, that the protection officers who are appointed by the government, state government, they are deemed to be the public servant under section 21 of IPC. And section 31 speaks about the penalty for breach of protection order by the respondent. If the respondent is violating the protection order passed by the magistrate, then either it may be interim or it may be final. Then he shall be punishable with imprisonment of either description for a term which may extend to 1 year or with fine which may extend to 20,000 rupees or both. So penal provisions are there. Now as per section 33, if protection officer, if the respondent fails or refuses to discharge his duties, the protection officer fails or refuses to discharge his duties as directed by the magistrate in the protection order, he shall also be punished. He can be punished with imprisonment of 1 year and or fine up to 20,000 or both. Now, here time is, I don't know how much time I am given, just few minutes I need. Here I may refer a case decided by the Supreme Court in respect of the Domestic Violence Act that regarding the live-in relationship. The name of the case is Chanmunia versus Virendra Kumar Singh Kushwaha, 2011 1 SCC. That is the citation. This is found in first volume of Supreme Court cases of the year 2011. Chanmunia versus Virendra Kumar Singh Kushwaha. In this case, which was decided by the Supreme Court, the question was regarding maintenance to be paid in cases of live-in relationship. Live-in relationships and presumed marriage, de facto marriage, and cohabitation cases, and the interpretation of the word wife. The apex court opined that broad and expensive interpretation should be given to the term wife to include even those cases where woman and man are living together as husband and wife for a reasonably longer period of time, and strict proof of marriage should not be a precondition for maintenance as per section 125 as well as Domestic Violence Act. So if there is a case for maintenance and there is a live-in relationship, then the wife, she is presumed to be a wife. She is not a legally married wife, but she will be entitled to maintenance. Then another case which I am referring here for a notice is the case. The name of the case is S.R. Batra versus Taruna Batra. That is of the year 2007, 3 SCC, page 169. In this case, Supreme Court interpreted the term shared household within the meaning of section 2S of the Domestic Violence Act. The shared household would only mean house belonging to or taken on rent by husband, or house which belongs to joint family of which husband is a member. It does not include the house owned by mother-in-law, the mother of the husband. So this was the term shared household was interpreted in this particular case. Now actually the shared household is a misnomer here, because I can point out certain loopholes in the Protection of Domestic Violence Act. Although the right of residence is given, but there is no substantive right of the woman just to get a shelter, where in a shared household, where she is the victim of violence. So this is like, of no use, because she has no substantive right. And for that purpose, I am just suggesting here that we should have, in India, we should have the matrimonial property law as well. Neither the women cannot get the legal remedy under Domestic Violence Act. And also I can suggest that there are that we have come to know about the service providers, protection officers. Very few protection officers have been appointed by the state government. If people go and make a survey, then very few protection officers are appointed by the government. So my suggestion is to appoint more and more protection officers in the various districts of a particular. Then there is a question of sensitization. Actually, laws might be there. There are a number of laws. There is an umbrella of international human rights laws, CEDAW, then other declarations, conventions, even national laws are there regarding violence. Under IPC, there have been many provisions. Any Dowry Prohibition Act is there. But the reality is that only law cannot solve the problems. There must be the change in the social attitudes of the family, of the society. Each and every member of the society must change their attitude towards women. Neither they cannot realize their legal remedies. And even I just suggest here, the service providers, police, magistrates, they must be sensitized in respect of gender issues and for issues of violence against women. If they are not sensitized and well trained, then the remedies which are available will be of no use. And there last but not least, the women should be made aware. The women, there must be the legal literacy program that in colleges, universities, we can arrange, our colleagues can arrange the legal awareness programs to make women aware of their rights, protective rights under the Protection of Domestic Violence Act. So again, I thank you. My special thanks to principal of this college, organizers, Dr. Shantanu Ganguly, Dr. Bernali Datta, then the members who are present here, governing body members, Navneeta Di, and all other people, those who have assisted to organize such a beautiful webinar, and I thanks all the participants who are present here for their patient hearing. So thank you all. My best wishes are with you. Thank you.
Shantanu, please unmute yourself. Please unmute yourself, Shantanu. You are not audible, Shantanu. Please check.
Am I audible now?
Yes.
Okay, good. So my heartfelt gratitude to our honorable resource person, Dr. Shochi Chakraborty, for a comprehensive and illuminating discourse on the nuances of the gender law interface that all of us were hitherto ignorant about. It is a matter of great regret that in India, women who were once revered with the words Yatha Naryastu Pujyante Ramante Tatra Devata suffered progressive social denigration down the ages So much so that once upon a time it came to be remarked, Dhol Gawar Sudra Pasu Nari Sakal Tadana Ke Adhikari. It is really very disappointing, and the situation has not improved even in the present century, and the lockdown has not done anything to improve matters. No wonder then that the famous Hindi poet Maithili Sharan Gupta, oh no, it's Makhanlal Chaturvedi, once regretted, औरत तुम्हारी यही कहानी आंचल में है दूध और आंखों में पानी.
अबला जीवन, yes, sorry, I may interrupt. अबला जीवन है तुम्हारी यही कहानी, आंचल में है दूध और आंखों में पानी.
Yes, from Yashodhara. So a beacon of hope may be identified in the way women can now become so empowered as to seek legal remedy and legal relief, especially through such sensitized people as the protection officers, the magistrates, legal counselors, and the internal complaints committee, the women's cell of any college or university can really play a proactive role in sensitizing female students as well as other women, so that they become knowledgeable enough. After all, we know knowledge is power. Forewarned is forearmed. So they become knowledgeable enough to know the different aspects of law which might assist them in seeking legal relief when they are subjected to violence from any quarter in life. So once again, I express my thanks to our honorable resource person, and we now move towards the eagerly awaited question answer session. I now request my colleagues, Kazi Shabnam Banu and Bhumika Pradhan, to take over. Those who want to ask questions, those present on this platform who want to ask questions or to make observations, they may unmute themselves and speak, or they may post their questions in the chat box. Those who are following this program on YouTube, they may also post their questions on the chat box, and we will be glad to present them to the resource person for clarification. Over to you, Shabnam and Bhumika.
Thank you, Shantanuda, and thank you so much, ma'am, for your valuable talk. Now here I find the number of questions have come for our honorable resource person from the participants. The first one is from Shubhra Bakul Karmakar. She is asking, Shubhra Bakul Karmakar, she is asking about, ma'am, what do you think that remedies are available for the protection of women against violence will be enforced properly in practice, as we are passing through a critical time, along with we have to adopt and accept new normal concept derived due to pandemic. This is the question from Shubhra Bakul Karmakar.
Can you repeat, please? Sorry.
Ma'am, what do you think that remedies are available for the
Yes.
protection of women against violence will be enforced properly in practice, as we are passing through a critical time, along with we have to adopt and accept new normal concept derived due to pandemic.
Yes, remedies can be availed and they can be realized also. But of course, there might be some problem regarding lockdown, that practical problems for transport and other facilities. So remedies are also available and courts are there and can be utilized. But the thing is that there is a lack of awareness, because the victims do not know how to approach these forums, that is even WhatsApp group, or there are certain online we can say that online service providers So they might not know, that might be the reason, but remedy can be aware and remedy can be realized also.
Okay, ma'am, the second question is from Rupsha Karmakar, and she is asking about what you think about laws against marital rapes in India, and also how PWDVA procedure works with those situations.
Marital rape, right? Marital rape, that might be a part of, although we have not recognized the marital rape in law, but still that can be a part of domestic violence. And if it is declared as an offense, then it is a kind of violence upon women. Even marital rape can be made an offense. There are suggestions regarding marital rape. When the wife does not give the consent, and then marital rape can be there. But without her consent and knowledge, without her consent, she will be. She has been. She has been. I can say that she is forced by the husband to have the sexual intercourse. Then marital rape should also be declared as an offense, according to me.
Okay, thank you, ma'am. Another question is from Lakshmi Narayan Mahato. She is asking, why do we witness larger number of violence in the North Indian state?
In North Indian states, larger violence, where how it is supported by any data, or how can we say that in North Indian states there are large number of violence? I can't understand, because without support of any data, of any justification, how can we say that there are more number of violence in North Indian states?
Okay, ma'am. Another question is, do you think misuse of Section 498A are increasing? From Sanjay Vishwas.
Yeah, several cases have been found that when the wife is claiming that there is a cruelty by the husbands and in-laws, sometimes they are misusing, because every law has a misuse. But we are talking about only 498A, misuse of 498A. So each and every law, even other laws have been misused. So not only 498A, but other laws have been misused. That I agree, but not only this, every other law can be misused.
Okay, ma'am. The next question is from Rupsha Karmakar. She is asking, ma'am, would you like to say something about late judgment of rape cases by Indian judiciary?
Which cases?
Late judgment of rape cases by Indian judiciary.
This time I have got. I can send my answer by WhatsApp. But right now I don't have any the record of the cases here regarding the rape cases. So I can send it by WhatsApp. There have been many cases.
Shohini Banerjee is asking, how can women avail of legal aid in West Bengal?
Legal aid, there is a Legal Aid Service Authority. Under Legal Service Authority Act, there are legal aid forums under the state legal service authority in each and every state. So people go there for those who are poor. Everybody is not able to get the legal aid, but the women, the vulnerable section, the children, they can avail legal aid under the Legal Service Authority Act to the state forums. There are state forums in each and every district. Sorry, in each and every state there are legal aid authorities. so they can avail.
Okay, ma'am. There is another question. Is that in from Sanjay Vishwas? He's asking about in how many Indian states online FIR can be done?
How many?
In how many Indian states? How many Indian states online
Yes.
FIR can be done? Online FIR can be done.
How, in
In how many?
all
How many? In how many Indian states online
Indian
FIR
states?
can be done?
Oh, sorry, I cannot tell you how many states in online FIR can be made. In some, it will be done, but how many states I cannot tell you the numbers.
Okay, ma'am. There is another question. Is honor killing a part of domestic violence, and who will fight for the justice of the girl killed?
Honor killing, of course, might be, yes, it can be taken under Domestic Violence Act, because when, suppose the father kills the daughter, because she has married in a different caste or religion, sometimes it happens that there are killings. So that can be also taken as a domestic violence, of course. But there should be a separate law. Till now, there is no separate law for honor killing. But the law has to be made by the parliament in this respect. Because it is also a kind of torture, violence, or even killing. So killing can also come, even it will come under murder also and Domestic Violence Act also. But actually, there is no use of filing a case under Domestic Violence Act, because already the person has been killed. So that will be the, because here the remedies are in the nature of civil remedies. Basically, the civil remedies are there in Domestic Violence Act. But honor killing, direct, you can say that it is a murder. Now it can be taken under IPC, and the remedies can be claimed there.
Okay, ma'am. There are so many questions, but due to short time, I have to move. Our question answer session has come to the end. Now I am requesting to Dr. Shantanu Ganguly to take the event forward. Thank you, sir. Thank you, ma'am.
Thank you, Dr. Kazi Shabnam Banu, ably assisted by Dr. Bhumika Pradhan, for presenting so many questions to our honorable resource person, which were all answered quite brilliantly. Before I move on to the last part of the program, which is the vote of thanks, I would like to inform all participants, both on Google Meet as well as those following the program on YouTube. A feedback link will now be posted. All of you need to fill up this feedback form. Please click on the link. A feedback form will open. All of you, please fill up the feedback form and submit it, and you will receive your e-certificate after that. So there is an embargo on 100 certificates which can be mailed in one day. So, once you submit the form, we will be sending you the e-certificate in due course of time, within the next 2 or 3 days. So the feedback link will be posted both on the chat box of Google Meet as well as on YouTube. Kindly click on the link and fill up the form and submit it so that we may send you the e-certificate. So that is all I needed to inform you. Now I request Professor Prabhash to deliver the vote of thanks.
Thank you, Shantanu. Good evening, everyone. I am honored and lucky to have the opportunity to give a vote of thanks on this special day. I would like to thank our governing body president, Dr. Abhijit Mujumdar, and respected principal madam for their encouragement and cooperation. I would like to thank GB member of Netaji Nagar Day College, Professor Navonita Chatterjee, for her encouragement. I particularly liked Dr. Chakraborty's speech, where she mentioned the need for awareness of legal remedies for women against domestic violence, especially in this pandemic situation. The way in which she explained this subject was extraordinary. I would like to thank her. I would like to thank all the organizing committee members, all the teachers, and non-teaching staffs of our college. I would like to special thanks Dr. Kaji Sabnam Banu, Assistant Professor, Department of Chemistry, and Dr. Bhumika Pradhan, Assistant Professor, Department of Botany, for their technical support and all types of cooperation. Finally, I would like to thank all the participants for making this event a success. Thank you all once again. Thanks.
Thank you very much, my junior colleague, Professor Prabhash Ondol, for suggesting the vote of thanks. With this, we come to the end of a great webinar in which all of us have been legally and socially sanitized regarding the violence that women face in society today and what they may do to seek relief and how we may aid them so that they are not discriminated against and they may seek timely help in the case of any domestic violence that they face. So we come to the end of a very scholarly session. I now request the principal of our college, Dr. Sonali Banerjee Josh, to formally declare this webinar closed.
So once again, Madam, many thanks. Namaskar on behalf of Netaji Nagar Day College. It was a pleasure hearing you, and we are really enlightened. But we would like to have many more such sessions because legal remedies is not a very easy thing, Madam. And from on part of the ICC and on part of our equal opportunity cell, if we could be of any use to women in distress, women in facing domestic violence, we would feel that we have done a bit towards curbing this menace which is affecting our society. So, ma'am, again, we would be approaching you, and in spite of your busy schedule, you have been with us, given us so much time. So, we are honored. Thank you, ma'am. I declare this webinar closed. Thank you, all my colleagues.
Thank you very much to Honorable Principal, Dr. Sonali Banerjee Josh. So with this, we come to the conclusion of this webinar. I'm sure in future, we will be meeting again and again with many such knowledge enhancing webinars, which have become the new normal in the academic world today and keeps us progressing and keeps us active. Thank you very much.
আছে আছে দিদি একটু স্লো আছে আছে
She is getting ready. Just
হ্যাঁ হ্যাঁ দিদি অন আছে একটু স্লো আছে
your video is not on.
হ্যাঁ হ্যাঁ দিদি ঠিক আছে ওকে 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 ডান
Thank you.
Okay.
Thank you, ma'am. Thank you.
ম্যাম থ্যাংক ইউ Okay, bye.